Okay, so the final segment of this chapter concerns the concept that we call undue influence, and we're discussing in this chapter events that can happen whereby one of the parties to the contract can ask the court for a remedy called setting aside the contract or rescission, which means to go back to where they were before they entered into the contract, to back to the economic state they were in before they entered into the contract. We talked about misrepresentation on the last time segment. Now undue influence. Now, if this event happens, again, a party can get their money back usually. Undue influence, as the book points out on page 199, is the domination of one party over the mind of the other to such a degree as to deprive the weaker party of the will to make an independent decision. This often occurs in issues or becomes an issue in disputes involving contracts or gifts or bequests under a will. For example, if I, as a lawyer, am drawing a will for an older person, let's say an older person than myself, let's say a 90-year-old lady, and in the will I put in a gift to myself. And she dies, her children are going to be upset that she gave me some money, and they're going to claim that I exercised undue influence over her because I had a special relationship with her as a lawyer and client, and that therefore that they shouldn't have to give me the gift unless I can prove that there was no undue influence, which would be hard to do in a case like that. So a lot of times in family situations involving inheritances and whatever, or gifts from parents to children, there's this issue of undue influence that pops up where one of the children gets something and the other children are upset that they got it, and they claim that their sibling, their sister or brother, exercised undue influence over the mom or the father who gave them the gift. That is the domination of one party over the mind of the other to such a degree as to deprive the weaker party of the will to make an independent decision. Where this is important in a business environment is in a situation usually where at a bank where the bank is loaning money to say a husband or a wife or spouses, and the bank as requires that the other spouse sign some security agreement to guarantee the loan to the other spouse. Very typically, let's say, let me be very traditional here, we have a husband that owns a business, and he's married, and he lives in a home with his wife that they own together, and but he's trying to get another loan from the business and from the bank, and the bank says to the husband, it's not enough that you sign a promise to pay back the money. We want your wife to sign that guarantee and to put a mortgage on your home. And the wife comes in and signs the documentation. And later on, why this gets into court is because the husband goes insolvent again or bankrupt, and the bank, he doesn't have the ability to pay the loan off, so the bank is coming after the wife to get the house or to get her to pay the loan or whatever. And the wife claims undue influence, that the husband exercised domination over her mind to such a degree that deprived her of the will to the independent will, and so on. There's a couple examples of these situations in the book at case 9.7 and 9.8, which I'd ask you to read. There's no question, there's no reason for me to read them back to you, but they're on page 200, and it's very important you read this case 9.7 and 9.8, and the section above that. I can read that back to you. under arrangements involving spouses. A spouse may set aside a transaction if he or she can prove actual undue influence. As well, some marital relationships raise a presumption of undue influence. This is true when one spouse traditionally relies on the other for major decisions. If a spouse's experience of business has persuaded the other, who has had little or no experience, to pledge her separate assets as a security or act as a guarantor for his business, a presumption arises. The dominant spouse must establish that no undue influence was applied. Otherwise, a weaker spouse may rescind the contract with the lender. You might want to underline that. Otherwise, the weaker spouse may rescind the contract with the lender. Two cases illustrate this. One is the situation where the court did grant the wife rescission, and in the other case, the court did not do so because she was fairly well educated, a real estate agent or whatever, and should have known exactly what she was signing. So in order to get around this problem of a spouse exercising undue influence or claiming that there's undue influence and allowing one of the spouses to get out of the contract, the guarantee or whatever it is, what we lawyers do is we get the weaker spouse to obtain what we call independent legal advice, which is dealt with at the top of page 201. So now, if I'm acting for a bank that's lending some money to a husband and they want to put a mortgage on his wife's house, I see to it that the wife, that the paperwork, all the mortgage document and whatever, or the guarantor, or whatever it is that's signed, that she doesn't sign it in my office or the bank. She signs it in front of her own lawyer, an independent lawyer who explains to her what she's signing and so on and so forth, and what the effect of it is legally. And then he provides a letter to the bank saying he's done that and that she doesn't appear to be have undue influence exercised over her, and that she knows what she's doing and is voluntarily signing this. And that, he then signs a certificate or a letter to that extent, or to that degree, and then that would stop her from claiming in the future, if the husband can't pay the debt and they go after her, that would stop her from claiming undue influence and rescinding the contract of guarantee or mortgage. I'm going to be giving you a couple of questions on the discussion portal to have, and maybe you can look at them and get back to me. I'll explain it more on the portal. You'll get them probably tomorrow, which is June 30th, that I'm videotaping this on June 29th. So the next day I'll get out some example questions that we can discuss both these concepts, a little bit more of misrepresentation and undue influence.